Not necessarily that Papa and I agree on everything. As far as technology is concerned, he's not very comfortable using it. I won't say that. I don't think we've ever discussed what he thinks about AI being used for research.
Drafting.
Or drafting. I don't think so. But personally, he may not be comfortable. Like, he needs somebody to set up even a VC hearing for him. Maybe he's become a little better. I always, from when I was a child, I used to say that, I want to be a lawyer. I think at that point, it also had to do with me wanting to copy Papa. So I wanted to go to I'm talking about a time when I had not even started school. So it was, I want to go to the same school as Papa, I want to go to the same college as Papa.
And you did.
To me, it was important to do things properly as a lawyer and as a judge. If work, as she told me, I used to say, I waited for work to come. So there are some things I felt I was not very good at sourcing work as people do. So I'll take longer to get work than somebody else who's better at it.
Right.
I think she faces that problem as an inheritance, genetical inheritance. We have to go forward. We went forward from partition. We can't keep doing this. So we've been through it, so we must go forward. We can't get stuck in the past. That's what history teaches us.
Off the record legacy with Justice Sanjay Kishan Kaul and Advocate Aakanksha Kaul. Thank you for joining us, Justice Kaul and Akanksha. It is an absolute pleasure to have you both with us today. Thank you very much for taking out the time to do this, in fact. And the idea today is to delve into some conversations that I have been very curious about so far as legacy, the flagship, is concerned. So the first question I definitely want to open up is about what law was like before it became a profession for you, Justice Kaul. In terms of, say, before the arguments, before the courtrooms, before the hustle of law, what was it like then? And also, when did it become a responsibility from a profession? Did it happen when you became a judge, or was that change transient?
So let's see, a lot of people said that lawyers determine themselves as a future in this subject very early, They are second generation lawyers, some of them judges' children. I never thought I'll join law. So that's the first thing. I was doing my graduation in economics from St. Stephen's, and I had appeared for the MBA exams, got a call from a couple of them. Wanted to do an MBA with the idea of sitting for the civil services. Reason was my fondness for travel. You have to remember these are 70s. And I thought a good method of travel was to become part of the foreign service. That's the only thing which excited me. And some of those people who were in that service, were related to me, had talked to me. So law was not a subject I had in mind till the very end of my graduation examinations, when the family seemed to be interested in my joining law because they felt that a job content would take me away, while a legal profession in the city would give me the leeway to handle the affairs of the family, which included considerable handling at Kashmir level. They got Justice Kirpal into it with a family friend, and I considered him a mentor in that sense, and he persuaded me why I should join law. He was still a lawyer, and he said, look, come and join me. Those were not times when corporates paid very high, nor did law pay very high. But he said, whatever you get from a corporate, I'm sure I would be able to compensate you if you join me. So at that stage, I changed and joined law, but never had any regrets. I think from the time of the law faculty, I enjoyed the subject because it is a live subject. And the Delhi University used to treat it by the case method of studies, not with a bookish way. So it interested me. I enjoyed the subject. I was also very clear that I wanted to be do a litigation work because of that. Justice Kirpal, of course, got elevated 6 months after I joined, and I confronted him with a breach of promise allegation that you got me into it. And I worked with my seniors after working for a short time with a law firm, shifted to a senior who had work in the High Court. I thought that is the middle level to start. I didn't want to go to district courts because of what I felt for the environment. I may be a misfit. I didn't go. And Delhi had the advantage of original jurisdiction, so it was quite fine by me, and so did my senior head work in different fields. So despite I took, that time you could take an advocate on record examination after 3 years, I took it, was I think lucky enough among the 3-4 people to get through at that time, but never really shifted to the Supreme Court. I used to go there to argue some matters,
Right.
but my focus was the High Court. So you gather work slowly. So it's a time period firstly when you work with the senior, there's a second time period when you leave your senior and you try to set up your own work. So there's a professional angle to it, that you want to make your bread and butter out of it. And to do that, you have to focus in that direction. But the subject should also be such as interests you. So when you ask this question, I enjoyed it and did it in whatever manner it came. If you compare it with judgeship, well, at that time, judgeship was considered an honor, and if you are given, very seldom declined.
Yes.
So when it came at an early stage. I didn't expect it that stage, because some norms of 45 existed prior to that, and it came in a nice way to me. Being the way I was asked was nice, so I said yes to it, and I had just been actually designated a senior advocate about a year before I was asked.
Right.
And in 3 to 4 months' time, the files used to move very quickly. I was on the bench. I'll say, comparing this, one question often posed to me is, did you enjoy the bar period more? Did you enjoy the bench period more? I felt I enjoyed both at the relevant levels. Of course, judgeship brings with it a sense of greater responsibility. Not that a lawyer is not responsible to his client, but you know what you say would decide the fate of the person before you.
Right.
But I don't think I ever hesitated in deciding what I thought was the right thing to do, not looking to all consequences. It's a mixed decision of head and heart, I always say, where the head has to play an important role and the law has to play an important role, but I think the heart also plays a small bit of it.
Interesting. And that gets me to a question that I want to put to Akanksha. Did the heart and the head fall in place when you chose law? Considering that you grew up in an atmosphere of law, and did you absorb it quietly, or did you over time realize that, okay, this is something I want to do, or was it a conscious discovery for you?
I think I always, from when I was a child, I used to say that, I want to be a lawyer. I think at that point, it also had to do with me wanting to copy Papa. So I wanted to go to I'm talking about a time when I had not even started school. So it was, I want to go to the same school as Papa. I want to go to the same college as Papa.
And you did. You went
to
St. Stephen's.
I did.
Right.
Although at that, when I had forgotten about it. So when I got through Stephens, I was actually quite upset that I had not gotten to, the few national law schools I had applied to. That time we used to have entrance exams separately for all of them, and I applied to maybe 3 of them. And then one of my friends, my childhood friends, reminded me, but why are you upset? You used to always say you wanted to go to Stephens because your father went. But so, it started off like that. And it was something that kind of stuck with me, that I wanted to be in this profession. Eventually, I think when it came to college, Papa encouraged me to not do the 5 years as well, and think about other professions. So I studied history, but I don't know when, from just wanting to be like him, it went into something that I was interested in, but I enjoy it. So, I've studied it quite a bit because I find it interesting.
Yeah, because you've been to St. Stephen's, and I understand you've been to King's.
Yeah.
You've been to Columbia for your LLM.
Yes.
And that also brings me to another question of foreign education, and whether that was something that you always wanted to do, and if it is something, firstly, from a larger perspective, helps the people to probably grow in the profession in a better way, or was it something that was like a bucket list tick mark for you, that I have to do an Ivy League, or that sort of thing. Also, whether there were any disagreements between the both of you about going abroad, what Justice Kaul would think about that.
Both Kings and Columbia at the respective stages in my life were great experiences. And I don't think that, it directly helped me. It's not like I'm going to get work or a client comes to me because I have a degree from King's College or Columbia. I don't think that matters so much. But in terms of personal growth, growth as a lawyer, they were great experiences, and I always recommend it to everyone. It opens up your thinking. I know my thinking changed quite a bit, or the exposure that I got has been immense. But Dad's always encouraged me to study. Even when I was going for my master's to Columbia, I was the one who was a little jittery. I was excited when I got in, went ahead, and then I think maybe less than a month before I was to leave, I was a little skeptical, because by then, having spent 4 years in the profession, I knew that if I go right now, I will end up losing the work, the private work.
Or at least the break comes in where, you stay out of touch with the whole practice hustle and everything.
I think also, your personal work in terms of the matters that have come to you, they're not going to come back to you once. When you're gone for a year, it's not going to, those clients are not going to come back to you. The filing's gone, somebody else is handling it. You can't go back and say, no, now give me the matter back. That doesn't happen. It doesn't work. But, of course, Papa encouraged me. His only thing was that if you're going only because you want to break from everything and you want to go and party, then I'll send you for a month or 2 months, whatever it is. Don't go for a year for that. But if you want to study, go.
Right.
And I actually spoke to a lot of people, got different advice. But one thing was there, that all the people that did not end up going despite an admission, including Papa, regretted it. So that was the reason why I ended up going. And in the larger scheme of things, 1 year here or there doesn't really matter.
Yeah.
It maybe pushed me back a little bit, but in the larger scheme of things, it doesn't matter that much. So
that tends to happen. Whatever experience you don't live at some point in time, you always tend to regret it. Justice Kaul, I'd like your opinion on that, especially foreign education, because there are opinions by a lot of people who are in the profession, older generation in the profession mostly. In fact, ex-Chief Justice of India, N.V. Ramana, had said that you don't need to do an LLM abroad to be able to get work or grow in the profession. What do you think personally, individually on this?
I always believed, even at that time or at her time, don't look at a direct benefit which comes into the profession. Look at it as an exposure to education. So I was also interested in further studies as a concept.
Right.
As a reasonably decent student. So you wanted to go there and get exposed to a different system of education. I believed a superior system of education. And the exposure to meet different people. Yes, it was very different. Those times even more so. Well, when you did well, people used to say only a third divisioner can make a good lawyer. And I used to joke with some of them that since you got third division doesn't mean that a first divisioner cannot make a good lawyer. But that was a thinking process arising because not two people academically inclined used to come into the profession. It changed, I think, especially with the national law schools. I think that's a benchmark where people who were good in their studies, good in education, and were not necessarily connected with the legal field, decided to come in. Initially, more in the corporate side because of the insecurity of the profession. But we are now finding a lot of people, senior counsels, other people who have come from national law schools, first generation lawyers, doing extremely well. I think that's a reflection of the position because, say, in the US, the best of the students go to medicine and law. These are the two fields.
Yes.
First generation people competing for law seats. Some of them, at times, their parents have an experience of coming to me where he wants to do law, but none of us are from law. Will he be able to do something there? And you tell them, look, there are many people now doing extremely well.
Yeah.
And with the transition taking place, I believe through national law schools, though I am still a believer that 3 years law course has still a very much place in our system because not everyone can take a call and doing a subject like law. immediately after school.
After school.
That's one reason I wanted to, she mentioned, to encourage her to go to St. Stephen's once she got in and think of other options. I said, don't do law because I did law.
Right.
I feel the next generation should get an option to do what they feel committed to do. I have seen my friends, some of them third generation doctors whose children have done law, completely reverse. So I think the next generation, the options are very many in fields which didn't exist.
Yes, yes.
And it should never be a hereditary issue. It should be something which you feel passionate about. Whether it's law, whether it's art, whether it's theatre, anything, whatever you want to do.
Akanksha, what was it like growing up in a space, in a family where there is also a lot of public image involved of your father when he became a Supreme Court judge? I'm asking this question from the perspective of also restraint, that as a person who belongs to a family where there is a public image or an institutional figure is in your family, what is it like when you're in that space? Because yes, there is a lot of fascination for people outside and there is a lot of maybe advantage also. But what did you feel when you say had to, I'll give an example. If you have to tweet out something, a person who's in a family, not from a lawyer's family or a judge's family, they don't have to think twice. But probably you had to. I mean, just thinking out loud. What do you say?
When Dad became a judge, I was still in school. I was in class 9. So at that point, it didn't affect my life as much.
Right.
He used to come to school a lot to give speeches and all of that because he was involved with the Alumni Association before he became a judge and after. So that
this is modern.
This is modern
school. Yeah.
So I don't think it affected us that much in terms of how we were living our lives. Maybe we were also younger. Again, Stephens, maybe, people came from all kinds of different families, and I think it's only if it's affected me in terms of having some sort of restraint, it was once I joined the profession, because I did my LLB also in London. Nobody knew. So in certain ways that was great, because you don't get any attention because nobody knows who you are, nobody cares who you are.
Yes.
It's only once I joined the profession that yes, you have to be careful. Maybe I've learnt my lesson maybe once or twice where I've written something, and Twitter I'm not active on, but and honestly, I mean, social media I do whatever I want to, but when it comes to, say, commenting on the law
issues which are, say, political, legal,
somewhere till he was a judge. And the other aspect of restraint, I guess, would be just being careful of, I had to be, thankfully no longer have to be, but who I'm talking to, or particularly like in terms of clients or work coming in, I had to find out where did you get my number from, or so look into the background.
That hesitation and pressure is always there.
It wasn't, that I could take on every matter that came to me, or all the work that came to me. I had to say no for various reasons. Maybe because I suspected their intent, or something seemed fishy to me.
Yes.
So yeah, the restraint I think was more in work related. Personal life, no. Partly also because Papa is not someone who changed his personal or social life after he became a judge too much. So that I've led my life the way I would have otherwise. But in terms of work and profession, yes, there has been some.
So is law discussed very often at home? Conversations, say arguments about something which is legal, political, any of those conversations that take place at home, Justice Kaul?
See, law used to be discussed at home earlier, because my father did law, had connects with the law, was not very actively into it. But meeting judges or lawyers was something I had seen from childhood. My brother was also a lawyer, so the dining table conversation would veer on to it, because we were in that time in a joint family system. that's the reason I wanted the children to be careful before making a choice.
Right.
So my younger daughter did designing, and she was clear she didn't want to do law from the inception. She was very keen to do law. So that's where it stood. So yes, conversation on a table can veer into law. The non-lawyers, I think, don't like it because they feel this should not be the only conversation.
Yes.
So one tries to balance the two things. But I was never used to, as a habit, after becoming a judge, of discussing anything which I was going to write or I had written at home. I thought this must be kept out to maintain that distinction which is there. Um, as she said, as a lawyer, so when I became a judge of the High Court, the idea was that she works with a law firm, etc., not come to the High Court.
Right.
So there was not too much of a time frame transition between the time I was a judge and she joined active professions. A couple of years she broadly kept out of the High Court.
Yeah.
I went away as Chief Justice, then there was no restriction, and I was away for 4 years as a Chief Justice. When she worked both in the High Court and Supreme Court, I didn't think it was fair when I came to the Supreme Court to again ask her not to come to the Supreme Court. So she did work in the High Court and Supreme Court both,
Right.
possibly more in the High Court because the comfort level is more because you began your work there and you get to argue. And if you're keen to do that kind of a work and not filing kind of a work, High Court may be a better place. I think I always cautioned her, and she maintained that caution, that never try to get into the middle of a matter. Okay, your fee charging should be commensurate with your standing, because I had seen sometimes judges' children charge more and then work didn't come because somebody is paying you not because you are
Yes.
you are so competent, but because they think that your being a judge's son or daughter would get you relief.
Yes.
So those are discretion which must be maintained. There were people I knew who had some kind of a tradition of engaging judges' children, and I had cautioned, and she, of herself, I mean, I remember once she came, she said, so and so is offering me work, but I have said no. I says, good, you said no, because you know the background of why that is offered. So that's both ways. Okay, so you don't make a killing during the time when you are a judge's child, but you are also more realistic in your thinking process of your own abilities and what you can get. So that's the positive and negative of it. And I think this is something which must be necessary. Even, one debate has been, should judges' children become judges or not? To my mind, there is no prohibition. But I used to tell, look, if I'm considering he's a judge's child, and this I said to sitting Chief Justices who discussed this with me, then that person has to be 10% better to get my approval.
Right.
This is a baggage you carry of being a judge's child. And I applied that while elevating lawyers as judges. Between the two high courts, at least 60 judges recommended by me were appointed as judges of the two courts. And the recommendations would have been maybe 75, 80. A couple of judges' children who went, it was not that I barred them, but I said they must be really good. If I compare two people in the choices between the two, you have to show that little bit of 10% extra, because you've had some kind of a privilege which is perceived in public domain of being a judge.
Right.
A child. Though I think at times, if you are really particular and up to it, it becomes it's a negative factor. Because people tend to say, oh, he's a judge. Whatever you do, it's a judge's child, even if you're doing on your own.
True, true.
And say if you're a lawyer's child, the lawyer is free to build you up. As a judge's child, I don't believe I'm free to build it up. I'm not saying it doesn't happen, but if it happens, it's wrongly happening. That's how I look at it.
Right. And Justice Kaul, the sense I also get from your comment is that there is, yes, access, but that access stops when the brief comes to the person who is supposed to get the brief. So that access may or may not be there, but when the brief starts and the arguments start, then it is in the person's space that they have to take it forward or not, and they have to perform. I think I do agree with you to a large extent, actually. And that is why one quick question I wanted to ask about office, the constitutional office that you held, was also about how it was post-retirement in terms of restraint, because as judges, public expression is something that is not usually done, actually not done at all. But a lot of judges do come out and give interviews about their journeys and everything. That has happened recently. What is your take? Did that expression change for you once you retired from office?
So let me say at the inception one thing. See, judges are supposed to be reclusive. They're supposed to be restrained. Reclusiveness, complete reclusiveness is not something I followed. I used to always say maybe I want to live my private life the way I want to do it. I felt I had the confidence to do my work impartially and live my personal life separately. You are careful, no doubt about it. So I was not completely secluded in that sense. And Delhi culture is like that.
Right.
So if there were school friends or college friends, it's not that I stopped interacting amongst them. You will not interact with your litigant who used to come to you because that's not your field anymore. But you don't eliminate your social interactions. That's how I looked at it, even when I went as Chief Justice outside.
Yeah.
So far as speaking is concerned, I think a judge should speak through his judgments. He may go and lecture in a law school. He may talk about some general subjects. I don't think the judge should get into a debate. That's not his job. On the lighter side, when I became a judge, I was sitting on the bench with Justice Devendra Gupta, who was like a judicial guru to me, I used to call him. I asked, as a lawyer, you're used to asking questions.
Right.
And arguing a little. So I tried to do that, trying to persuade a lawyer to what I felt was right. And he told me, see, this job you have given up now. You are not meant to argue. The pen is in your hand, you ask a question. If you get an answer, well and good. Otherwise, keep quiet and write what you want to write. That grows in you. So for 22 years as a judge, you are taught that you must speak through the judgments which are there.
Right.
Today's the social media at times, takes you on even oral utterances in court.
Yes.
Which occurs. Now, oral utterances are often necessitated by giving an opportunity to the lawyer to explain his case better, or if there's something troubling your mind.
Yes.
A quiet judge is a dangerous judge to my mind, because the lawyer will not know where is he going and what is troubling his mind. So, he would like a judge to express his view, but that's not a view for the judgment, that's a view for inquisition and opening. And the negative aspect of this which is occurring today is, I think, the judge can become more quiet than necessary.
Yes.
He can become more quiet because he doesn't know, he'll have to think twice over how in public domain it will play out. So if I look at my High Court's tenures and my Supreme Court tenure, by the time I reached the Supreme Court, this trend had grown and you were the highest court. So I think even in questioning, I was more restrained than I would be at the High Court level.
Right.
And that's so it plays both ways, this concept of visibility in the public domain, because often a legal person will understand why a question is being asked for or answered. A person who is not connected with the legal field can draw all kinds of conclusions or perceptions,
Yeah.
which a professional in law would not draw. So that's the challenge today we face.
So context matters always, yes.
Yes, and
Yeah.
after retirement, of course, there are no restrictions on the nature other than your own habits which have grown over a period of time. So I have, for example, I gave more than a couple of interviews just after my retirement. 4 days I was too busy in these interviews, and that's it. Whatever I had to say, I have said. I had certain views on some things which was asked. It was becoming repetitive, so I stopped. After that, I've appeared in different podcasts and things on subjects of general public importance. You know what to talk, I think, by that time, and what not to discuss. It's not necessary that every question needs to be answered.
Yes.
Because in some way, you carry a small part of the baggage of being a judge. And you know that you are also being asked these questions because you have been a judge.
Correct.
And there are issues which you agree with, there are issues which you don't agree with. And you should be able to state within certain parameters, I would say. So I've appeared in all kinds of debates and all kinds of issues, but I think about it before appearing. I don't just say, if I start saying yes to everything, then I'll only be doing this, which is not what I want to do. So I always thought post-retirement life was about many things to do. And I believe I am doing many things. That's one reason I had said from the inception, I will not accept a government assignment. So people ask, do you think a judge should not? Actually, up to the judge.
Yeah.
There are tribunals to be manned by judges. So how will they be manned? But I don't want to do it. That's I thought 22 and a half years was long enough.
And I'd like to come back to you on Kashmir Justice Kaul in a bit. But I want to ask Akanksha, with all this pool of knowledge that you have about law and all the opinions that Justice Kaul does carry about the profession, about judgeship, what do you do differently when you build in terms of your work? And do you differ in certain ideas, certain thought processes? Say, for example, technology for that matter. Not that I'm assuming that Justice Kaul may have that opinion about technology, but a lot of traditional lawyers, older generation lawyers, steer away from technology. In fact, a lot of judges also say that no, AI cannot be used as judges. There is a subtle, backshift. They take a back step when it comes to technology. What do you think about that? How do you think the change is required or not? Do you think traditionalism is something that should be kept alive in the profession? Tell us about that.
No, I think everything that needs to be changed, everything needs to move with the times. Not necessary that Papa and I agree on everything. As far as technology is concerned, he's not very comfortable using it. I won't say that, I don't know, I don't think we've ever discussed what he thinks about AI being used for research.
Drafting.
Or drafting. I don't think so. But personally, he may not be comfortable. Like, he needs somebody to set up even a VC hearing for him. Maybe he's become a little better.
Right.
Always used the hard copy files, no e-files for him. I don't keep any hard copy files anymore. So those kind of small differences, of course. I don't think I presume he also believes in moving, that things
forward
need to evolve. I mean, he's always focused on, he told me when I went independent that you'll have to have a lot of patience, because it's not like work will come immediately.
Yes.
Be prepared to wait it out, and work will eventually start coming in. But keep reading and keep learning. And law involves a lot of constant learning and studying. It's a constant process. So I think that is something that I've taken from him, that we're always learning something new. It's not a job where you can say that, I've learned everything. There's nothing more to learn. No matter what stage of the profession you are at, or what stage of the career you are at, you still need to be a student of law.
Right. I think when it comes to establishing yourself in law also, it's a transient process, but I genuinely personally feel like there can never be a number to it. Like, people say, 5 saal mein you will start getting work, or 7 years mein you will start getting work. It's never like that. No matter what access or what influence you may carry with you, I think that timeline can never be decided. It all depends on a lot of opportunity that comes your way also, and your performance. So that's what I think. Coming to Kashmir, that Justice Kaul also just mentioned, I'd like to take both of y'all's view. Justice Kaul, you authored the judgment also, 121-page concurring note judgment that you authored. My question to you is stemming from the lived experience that you carry. Of course, you were born and brought up in Delhi, but you have spoken in the past about the fact that you had a 90-year-old home that was burned down during the genocide. What is your take on having a conversation about Kashmir, or when you were penning down that judgment at home when you were doing the hearings? So you did say there is a difference when I'm in the court, and there will always be like a separation. But is it possible always? Because when you come from lived experience, when you have a sense of understanding of what my people went through, or what my community went through, there does tend to be some percolation or perceived thought process in it. So any questions or conversations that you used to have in your mind or at home or in the family when you were doing the hearings prior to the pronouncement?
So just understand the background of me and my family limitedly. We were at the receiving end of partition. My family was based in Lahore in Kashmir and Bahawalpur. Bahawalpur and Lahore went there. So the first loss was that concept, and from your grandparents you hear about it.
Yes.
So you imbibe part of it. Similarly, Kashmir, it was Kashmir in Delhi. I had my education in Delhi, but my grandparents used to go there, and I went there. So post Kashmir problem, I said, see, in a period of 75 years, the family saw two great upheavals. Yet we learned to grow with the first upheaval. So we have to learn to grow with the second upheaval. Yes, I may understand the problem there better. Since I was based in Delhi, so I didn't have very many relatives staying there in Kashmir. Kashmir has seen 7 migrations in its history of the Kashmiri Pandit community. This was the 7th one. So people have settled all over. That's why in the country you see. Now, there are some difference in traditions and conventions there, and very few went back. My family was one of the rare examples where, after having migrated out of Kashmir at some stage, came back to Kashmir. So it was a redeveloped interest some couple of generations ago into coming back to Kashmir. With the result, we were not having a large social interaction there, but we had assets and properties there. So twice there is a sufferance element. But then my thought process was, we have to go forward. We went forward from partition. We can't keep doing it. So we've been through it, so we must go forward. We can't get stuck in the past. That's what history teaches us. Many countries, many societies, many groups have gone through various upheavals. And yes, the loss is always problematic. But I thought I understood the problem more, because I felt there was this upheaval of the community which had not been acknowledged. One of the biggest grievances of the Kashmiri Pandit community was that there are a lot of people who don't understand what has gone on.
Right.
How the displacement has occurred, and you keep assigning it to different reasons, not understanding the gravity of what had happened there. Similarly, once the law and order had to be controlled, army moved in. Army are meant to fight wars. There was a war there. When you fight wars, there is collateral damage in the war which occurs. So there was a local population, Muslim population staying there, which also had affected people in this. I thought that everybody has to grow out of it. Maybe the people who've grown later never had the benefit of seeing an interaction with Kashmiri Pandit community. Those people who had migrated did not appreciate that the people who stayed back also had their problems. And so, if we have to move forward, we have to acknowledge both facts. I took an example out of the Truth and Reconciliation Commission of South Africa. Why? Because South Africa had faced an apartheid issue, and the purpose was not to prosecute people. The purpose was to acknowledge what had occurred. People came to these commissions, people cried who had killed other people, but there was some kind of a burial to the whole issue to move forward. Why I said that was, I felt there is a need for acknowledging what has happened between 1989 to the times which we are here, for all the affected people.
Right.
Not with the idea of prosecuting anybody after 30 years, but acknowledging this is which has happened wrong, and how to remedy it in a social system. So I never had a hesitation in accepting a position on the bench when it was told that I will be there. I felt I could contribute to it. See, we all grow in many ways. There are many cases which come your way where, if you want, you can take identity. For example, let's take a landlord-tenant dispute. Somebody may be a landlord, somebody may be a tenant, but when you sit on the bench, you decide the issue on the basis of the fact and the law.
Right.
And so those are simplistic examples. This is a more complex example. But the fact is that as a judge over a period of time, you are trained to keep your personal beliefs under check and decide on the basis of law and the facts on record. And as I said, some part of the heart also plays
Yes.
a role. So, no judge can say that he is, in that sense, completely disassociated with the subject matter. You will always carry a little bit of the baggage for anything. That's part of your upbringing, that's part of your education. But a part of your training is how to keep that subdued and not affect what you're deciding before.
Yes. Akanksha, do you remember any of the conversations perhaps which unfolded around the hearing? Any thoughts that you want to share with us so far as that cultural identity is concerned and how that played out with the Supreme Court judgment that also Justice Kaul authored?
So I didn't know what he was writing till it was pronounced. He doesn't discuss. So, and I was not involved in his office at all by then.
Right.
I was working on my own. So I don't think we ever discussed what happened. Of course, I mean, I followed the hearing at least in parts, not entirely. So I've never, of course, I was born about 2 years before the whole problem started in Kashmir.
In 1995, we went in we had not touched the Kashmir house because people shouldn't feel we are taking away stuff.
Right.
It was there, our staff was there. But by 1995, the peak of the militancy problem. When they said they'd taken stuff, we went back to get a truckload of old furniture, some photographs, memorias, some books. I had very, very unique books. Some of them I display here as prints of it. So things connected with our family.
There was
and
that
history.
house.
That's how it was. Yes, it survived. So it's a 120 years old house, 903 built house. That house somehow survived because in a safer place. So things were cleaned out. And 2 of our cottages, which were in the orchards, were burned down over a period of time. One in 1990 at the beginning of the problem, other in
2003, that was the...
5, I think.
5?
5, I think.
Okay, then we've been going since 2005.
5.
That was a different house. I mean, I've heard stories of, there's one cottage which was bombed at the peak of militancy. There was one which, whenever we went 3 or 5, I remember that was after my grandfather was diagnosed with cancer, and we had all gone, the entire family, and we went to see this cottage we had. It was sealed because the government was trying to acquire that land at the time. And I remember peeking into the cottage from the windows. There were glass windows, and we all just peeked in to see. It was empty. By the time we landed in Delhi, that cottage had also been burnt.
Oh.
So, I mean, these are the kind, it was a wooden cottage. So these are the kind of stories or association with Kashmir that
So when the judgment came, you were practicing.
Yes, yes.
Would you like to share your opinion on that judgment when it came? Did you hail it? I mean, I'm thinking out loud. If I had an opinion about something and somebody in my family had passed a judgment on it, I would definitely hail it or disagree with it. So if you'd like to share something about that, if you're open to it.
I don't want to comment on the judgment.
Right.
It wasn't until too long ago, before the judgment, that I would have not even inherited any property. So, because so you had to be a state subject to be able to inherit property in Kashmir.
Yes.
And the law was at the time interpreted such that if a woman, a state subject, married a non-state subject, and not, mind you, not all Kashmiris are state subjects.
Correct.
They would lose their state subject right, and then you could not own property.
Yeah.
So that itself had changed only, I don't even know, 1990s,
90s, the judgment came of 3 judges bench, which said that this method of succession was wrong, and the daughter, despite the marriage, would get a state subject right to continue and thus own property. So I used to joke with my wife that her certificate, because she was a non-state subject before marriage, by being married to me, she got a state subject right.
Right.
So her state subject certificate carried till married to so and so. My daughter's certificate that they were made did not carry this chapter because they could, for their lifetime, be a state subject.
Retain
But
it.
that's one of the issues came in 90s. But things that, well, this problem was slowly by social transformation being solved. But 370 was a little different cup of tea. The whole thing arose from a principle whether it was transient in character or was it a permanent feature of the Constitution. If somebody would say, what is the crux of it? It was this, I think. The debate was whether it is so. There were people who believed no, this was to be a permanent feature of the Constitution ad nauseum. And there were others who felt it was a transient nature. Over a period of time, many things had gone out of it. So, I remember in terms of, during the course of argument, putting it to one of the eminent lawyers who was appearing for the Supreme Court of the Srinagar Bar Association. I said, look, broadly a shell and something remains only. 80% is already gone. It has been diluted over a period of time.
Right.
So you said, no, but then why take the shell away? That was his view. I said, why should the shell be there? Because the other perception was, well, it creates an artificial distinction and in assimilation in the country. And that's not good. So this was the debate, but we were testing it on a constitutional parameter only.
Right.
And we felt that the 5 judges bench felt it was transient in character. It could be changed and it could be obliterated as it been done. I think the more difficult question to answer there was the manner of doing so. So there was some debate internally on the manner, but ultimately the judgment said what we thought was the correct view.
Right. And Justice Kaul, one more question about you taking a stand on the fact that the judiciary cannot be expected to act like an opposition against the government. You'd said that in the past. I also want to bring in Akanksha here later about politics and law, if at all. Thinking out loud, do you think law and judiciary and politics are interconnected, or it is only lawyers and politics which is interconnected? Is judiciary completely insulated from the politics of things, ideology of things?
So there are two stages. See, when a lawyer becomes a judge, he can't come with zero political baggage. Everybody has been a voter at some times, has, I would expect, voted. Some states, the divide politically is more. For example, in Tamil Nadu, the division between the DMK and the AIDMK was extremely strong. There were people believing in both. So when elevating judges, I would make sure that somebody not overcommitted on politics should be the judge. So there could have been a lawyer in DMK time or AIDMK time. I recommended both and both were appointed. So other thing is, as judges, at least as a Chief Justice, there has to be, interaction between the Chief Justice of the High Court and the government. Because in terms of law and order, infrastructure development for judiciary, finances, these are all with the state government. So there is a interrelationship which has to be maintained for creation of congenial circumstances in which the judiciary can render justice.
Right.
You are not supposed to go by the political beliefs, but judges also vote. Now suppose a judge goes and votes. Can it be said that because he may have voted for a party on judicial matter, he will go with what that party propagates? I don't think that's the position. So, when I say that the judiciary should not be role of an opposition being played, what I mean to say is, don't use the judicial system, the opposition. Fight your battles somewhere else.
Outside the court.
If there's something constitutionally affected, etc., you file cases in court. But don't expect the court to be a bulwark against the government. Yet, there is a thin line. The thin line is this, that the intrinsically judiciary is perceived as anti-establishment.
Right.
Or possibly should be. That is because it is the check and balance institution. Government will not decide matters in favor of what the opposition's belief is. They will decide in terms of what their beliefs is. So cases which affect the government, not every case, but some percentage of cases affect governance issues. And there, if the constitutionality is challenged, it is the job of the court to decide it and also keep a check and balance in the whole system. See, we adopted democracy, first past the poll. We could have had another system, some proportional representation, etc. Most governments have worked with less than 50% vote percentage. So it can't be said that the government has a carte blanche to do whatever it wants. Judiciary becomes somewhat of a check and balance to see that the decisions of the government are, meet the touchstone of the constitution.
Right, Justice Kaul. Akanksha, your thoughts on the polarization. There's a lot of polarization now. People have a political view on everything. Do you see that in the profession as a younger lawyer?
I do. I do see that in the profession. What I sometimes, or I do find a problem with is, I can have a different opinion, you can have a different opinion, we can still be friends, we can still have a debate. Point is not for me to try and convince you that you are wrong.
Right.
But there is this desire to kind of convince the other person that they are wrong, and because you don't have the ability to tolerate that somebody else has a completely different opinion from you. And I do see that a lot in our profession. I see a lot of people adopting certain views because they feel that would further their career. You speak to them and it's not that those are their views or they feel as strongly about them.
Yes.
But it's just because they feel that would help them go further in the profession.
As a projection, so as to speak.
I was once advised by somebody to join a organization. I don't believe that's the right way to do it, but that's my personal view.
That's your personal view, and that's great. You should have one always, yes. And I totally agree with you. There's a lot of polarization, a lot of projections, a lot of performative ways of functioning may have come out, especially with the advent of social media now.
Yes.
A lot of views are now made public also. One last question I'd like to ask both you and Justice Kaul is about legacy, what it means to you personally, individually. When it comes to legacy in the legal profession, what is it that perpetuates the continuity in it?
To me, the legal system and being part of it also imbibed those value systems. To me, it was important to do things properly. As a lawyer and as a judge, if work, as she told me, I used to say, I waited for work to come. So there are some things I felt I was not very good at sourcing work as people do it this way. So I'll take longer to get work than somebody else who's better at it.
Right.
I think she faces that problem as an inheritance, genetical inheritance. The other is that as a judge, it was always felt that it should be an honor which must come your way. So intrinsically, I take a pride in the fact when a Chief Justice of India tells you that he would like you to join the bench, I felt that satisfied my parameters. As a judge, I felt that as a human being, you want to live life with some dignity, with some value systems. And maybe the only concern I used to have as a judge was that I want to retire with a sense of dignity. That I have, it's not that everything I write is the right thing, it's not the best thing, because people will have different views, people will have different expressions. But what must be understood is I have tried my best and I have done it honestly. And that's something which worked with me towards the last couple of years, that I should retire with my value system and dignity intact. And that's something I'm proud of. That I was able to take difficult calls, sometimes against the government, but that's because I believed it so. It's not that I was trying to make a point against the government, or if I decided something in favor of the government, it was not that I was trying to give an obligation to me. I've had people, friends at times question me later on. For example, one of my judgments was M.F. Husain, which was hailed as for artistic freedom. And when I wrote the judgment in Rafale, one of my friends asked me, how could you do it? I said, I don't have to write what you think is right.
Yeah.
I have to write what I think is right. I do believe in artistic, social freedom, but I feel there are some roles which the government does, and the government is best left to do the role unless there is a financial irregularity found and proved in that transaction. So, one is decided cases for government, one is decided cases against government. Yes, I always believed when I joined, somebody told me, see, in a country like ours, there is the common citizen is at a receiving end, and I believe that's true.
Right.
So, if it's a 50-50 case, you can go 55 in favor of the citizen. Don't go against him as 45. And that's something which I've kept close to my heart, that if the citizen against government, then it's a equal scenario, then weigh in favor of the citizen, because the government is an institution, a monolith.
Yes.
And individuals come to court only as a last resort. Nobody likes to litigate.
Correct.
People come to court when they are not able to sort it out other ways, and I would go to extend legally or illegally sometimes. And because our system takes too much of time, the legal system takes too much of time. Nobody wants to get into it. It's a last resort. Don't disappoint him in the last resort if he deserves something. If he is misusing the system, throw him out.
Right.
And I think the challenge today, I feel, has become even larger, because the legal system is taking definitely more time to decide what is right and what is wrong and where you stand. And the social glare is such that there is sometimes a little hesitation in deciding. I'm not saying deciding for him, in deciding. So things get prolonged longer.
Yes.
And I think the judge's call should be to take a decision, what he believes to be the correct position, in a reasonable short period of time, conscious of the fact that he is overburdened with a lot of work, and the systems all not necessarily subserve him. So, the greatest satisfaction I've had in mind is, which I wanted to have, was that the end of the day, when I leave as a judge, it should be with my integrity intact, and that perception in public, though it's not something you should look to public approvals, but some way that perception does become important when you hold an office.
Great. Justice Kaul, you've also been very vocal about judicial reforms, and I hope we get to speak to you about that some other time. Akanksha, any reflections?
He's left a large impression on the profession, and his legacy is a big one to carry forward. So I just try not to damage what he's built, and hopefully with time, in our profession, you take time to grow.
Yeah.
So hopefully to build on it and take it forward.
It was so nice talking to both of you. The conversation was very flowy, and I really enjoyed the candidness of it. So thank you very much.
Thank you for having us.
Thank you for having us.